On December 3, 2024, felony probationer Marlon Zenon was taken into custody in Harris County, Texas, after officers located him on an active warrant. During the arrest, police also added a charge of interference with public duties after claiming Mr. Zenon refused to place his legs fully inside the patrol vehicle and stiffened his body to stop officers from securing him inside during the arrest process. Attorney Gregory Siros was later assigned to represent Mr. Zenon as the case quickly moved into court proceedings. Just 2 days later, on December 5, 2024, Judge David Fleer of the Harris County Criminal Court in Houston, Texas, held a probable cause hearing to decide whether prosecutors had enough evidence to officially move forward with the interference-related charge against Mr. Zenon.
2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're 0.1 mile away from the location. So for what?
Well, okay, I get that. But so we've got a disturbance at HEB. Cops go there. Okay. They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else. Was there another warrant that you said?
It's the aggravated assault. But Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this, for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Hold on. Let's pull up the code.
Intake could have taken some other things, but
well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can, that you can charge someone with facts, right? There's multiple ways that can, you're right. It could have been like a resisting, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree.
Okay, so the cop can claim anything is interfering with public duties. Constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty.
Mr. Siros argued before the court that the interference statute itself may be unconstitutional because the wording of the law is too unclear and confusing for ordinary people to properly understand. His argument focused on the legal principle known as the void for vagueness doctrine, which comes from constitutional due process protections, requiring criminal laws to be written with clear and specific language. The United States Supreme Court explained in a major 1983 ruling that a criminal law can be considered unconstitutional if regular citizens cannot reasonably tell what behavior is actually prohibited under the statute. The court also warned that vague laws create a serious risk of inconsistent enforcement because officers may end up deciding on their own what actions deserve punishment without clear legal limits. According to the ruling, laws lacking proper detail can give police extremely broad authority to arrest or charge people based on subjective judgment rather than clearly defined conduct. Because of that concern, Mr. Siros argued that the interference statute opens the door for arbitrary enforcement, since the law potentially covers a wide range of actions without clearly explaining where legal behavior ends and criminal conduct begins. His position was essentially that the statute fails to provide enough guidance, both to the public and to law enforcement, which could allow different officers to apply the law in completely different ways depending on the situation.
Bigger issues. They should have taken the other charges, my whole point.
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
That's assuming they even had the right to do that. He's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing.
Mm-hmm.
That's what they were investigating.
And the witnesses all described.
They put him. I guess did they put him under arrest at the time when he said that he was making that threat?
And with being
did they have the authority to arrest at that time? Right.
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant. And then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing. That's a resist. That's not interference with public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, with which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay. Well, I mean, but
we don't know. I mean,
okay. I'm just saying.
Well, he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet.
don't
I
Judge.
don't care. I mean, but I think that there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
remember-
You're right. I haven't had a
Guys,
chance.
this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening.
Mr. Siros argued that the accusations against Marlon Zenon may fit a resisting allegation, but should not qualify as interference with public duties under Texas law. Judge Fleer responded during the hearing by stating that he believed the reported actions were enough to establish probable cause for the interference charge to move forward in court. The judge reviewed Section 38.5 of the Texas Penal Code, which explains that a person may commit interference with public duties if they interrupt, disrupt, impede, or interfere with an officer carrying out a lawful responsibility. During the hearing, the court also discussed previous rulings from Texas-related cases where judges determined that refusing to follow lawful police instructions can sometimes qualify as interference under the statute. Because of those earlier decisions, the court suggested that refusing to place legs and feet inside a patrol vehicle while officers attempted to complete a lawful arrest could reasonably support the interference accusation. Prosecutors argued that straightening the legs to stop officers from securing a suspect inside the vehicle created a physical obstacle that interfered with the officer's ability to complete their duties. The hearing then shifted toward the separate issue of resisting under Section 3803 of the Texas Penal Code, which applies when a person intentionally obstructs an arrest, search, or transport by using force against an officer. Although the law specifically mentions force, Texas courts have previously ruled that force does not always require punches, kicks, or direct physical attacks against police officers. In a 2016 case, the Texas Court of Criminal Appeals determined that a suspect who tightened his body and pulled his arms away from officers used enough opposing force to support a resisting charge under the statute. Based on that earlier ruling, the court suggested that extending the legs to block officers from placing someone inside a patrol vehicle could also be viewed as physical resistance under Texas law. Because of those legal precedents, the judge appeared to believe there was at least enough evidence for prosecutors to reasonably argue both interference and resisting during the early stage of the case proceedings.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so
the bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body camera.
I just shared
Okay,
it.
so
They just shared it with me.
Yes.
let's roll it.
Judge Fleer ultimately ruled that enough evidence existed at that stage of the case to support probable cause for the charge against Marlon Zenon to move forward through the court process. Even with that decision, the judge also acknowledged that additional arguments could still be important once both sides had the opportunity to carefully review the body camera footage connected to the arrest. Rather than making a final decision immediately, the court agreed to continue the discussion during another hearing scheduled for the following day. The judge explained that watching the actual footage could provide a clearer understanding of what truly happened during the struggle near the patrol vehicle and whether the officer's account matched the recorded events. That decision left the case open for more legal debate as both prosecutors and defense attorneys prepared to closely examine the video evidence before returning to court again.